Guys, it's Kathy. I hope you're doing well. All right, we made it. We made it to the end. So we're going to find out today what happens. This case is dismissed or it's not. It's pretty much what we're going to find out today. So, quick recap. Aaron Bell, lawyer. He's being pulled in front of the Office of Disciplinary Counsel for he's being punished because he didn't fill out his paperwork correctly. That's a good summary, right? I think I nailed it. He didn't fill out his paperwork. He didn't check all the boxes. So that's pretty much it, right? If you want more information, please see prior videos. Here we go.
So, in the Myers case, let me back up. From your testimony, you and your clients made a decision not to attend the arbitration in the Miller and Myers cases. And I understand your testimony as to why your analysis of the law. On June 11th, there's a non-pros in Myers that says there's no right to appeal from this. And that's still before the arbitration hearing is going to happen in the Miller case. My question is, did the fact that there had been a non-pros issued in the Myers case affect at all your strategic thinking about whether to still not show up on June 20th in the Miller arbitration? Because you knew what happened after the first one. They didn't show up. Did that factor into your thinking at all about whether to go to the second?
No, because the clients, we were aware that if you don't go to the arbitration, they're going to null process. Because you don't show. Anybody who doesn't show, they're going to null process. And we were just going to file the 3051 motion and explain to the court the reasonable basis for it. The form did not have the jurisdiction to give the clients the amount that they saw. And I informed that to the clients. I said, and I gave them a copy of the cases and where this happened. I recall discussing with them the RHI. We talked about the Hall versus Reed, and even the Katluki case, the Katluki case, that non-published opinion from the Superior Court. And I said that it will have to go this route. If you want to have a jury trial, they're going to enter a non-suit on you here, and we're just going to appeal, and then we're going to have the trial. So we made that decision. They did not want to arbitrate their case for less than the amount that they asked, especially Mrs. Myers. And they didn't want to do it. And I gave them the options. I said, we can go, but you can't get any money. And I also informed them that arbitration is like a scrimmage, because the arbitration hearing, anybody can appeal, even if you don't even put on an ethical case there. You just go there just to be there. And let's say you get you don't even have to. Let me be more clear. The judgment of the Board of Arbiters is not binding. Anybody can appeal it, and you're automatically entitled to have a new actual trial. And my clients they didn't think it made sense for them to arbitrate the case for less than they wanted. And I further had an issue with if I would have went to arbitration, because look, we have to be competent. And I didn't want to go to the arbitration panel and ask that panel for a relief that we couldn't.
Micah, you have to put your tie on. I don't know why. Go put your tie on.
We only can get $50,000 exclusive of interest and costs at arbitration. My client was seeking in excess of $50,000 for each count. I'm not gonna go to the arbitration panel and ask them to reverse the law because they
Thank you
don't
for
have
the
the authority to
cheers,
do it.
thank you.
I didn't want to make a frivolous argument to the panel. And that's another issue that I talked to my clients about. We talked about the cases, they made their choice, and I further explained to them that most likely we would have to, this matter is going to see in appellate court someday. Because when the judge made his ruling that what the amount of the cases were worth without employing any of the discovery options and tools of the court, or even like just a rule to show cause to hear, our opinion. I told the client that it's a good chance that even if this was a jury trial, and let's say we won some money and it was more than Mr. Hubbard asked, the court would probably enter a remittitive. And I explained to him what that was, and I explained the court had prejudged all of your cases. So it's like, I told him that we were in rocky terrain and I'll just do whatever I can. And they didn't see arbitration as making any sense. It didn't give them the relief that they wanted. They wanted a jury trial. And I told them, I tell everybody, you don't know what a jury's gonna do. That's one thing you can't guarantee the outcome of nothing. And the jury, just even a judge trial is unpredictable. There's no guarantees in this business. They made their choice, and I don't think they made a bad choice. They didn't want to litigate their cases for less than $50,000 in order to have a trial that we submitted the proper paperwork, we paid all the fees, we complied with the statutory law. I did not reinvent the wheel. I just was following the roadmap already laid down.
Thank you, Mr. Vallon, for that. Finally, with respect to not seeking a la carte from the Pennsylvania Supreme Court, did you consider petitioning for a la carte, given, as you testified, the way that you read some of those superior court cases, that they arguably reach a different result than the Commonwealth Court did here? At least that's been your testimony. Did you consider asking the Pennsylvania Supreme Court to resolve the different approaches of the Superior Court and the Commonwealth?
Absolutely. And when that 30 days was ticking down, and I talked to the clients and I told them, and then the Supreme Court is tough. The Supreme Court is good though if you can get your case there, but it's tough. And I've thought about it. I remember on the 29th day I was thinking, so we just allocated this, and the client said, well, if they're not gonna grant it, why would you do it? And I said, well, it's the chance. It's probably like a half of 1% chance. And I was looking for other cases similar because, all right, so with the allocator, our state is just like the federal court in a way. We're just like a mini federal jurisdiction. Usually, like for the court to grant the federal court got the 1254s, the certiorari, we got the allocators. But the courts want, because the Pennsylvania Supreme Court is not a error correcting court. There's only 7 justices up there. So they only hear cases, is a new issue in law, constitutional issue or something like that, and they probably would have accepted the case maybe if there was a more significant, conflict in the appellate courts. I couldn't find any other case that ruled in a similar way as the Commonwealth Court, and it was just one bad decision in our opinion, in 2 cases combined as one, but I didn't think it was enough conflict between the intermediate appellate courts to be able to present a serious question that the Pennsylvania Supreme Court would have granted allocator on. It wasn't enough conflict. We just had this one case, and then if we would have just presented this case with us, it would have been like, it's just okay. It happened one time, and the Supreme Court is very clear. We are not a error correcting court. And at this point, I didn't think that we had enough conflict between the Superior Court and the Commonwealth Court. In the Commonwealth Court, in this case, they said this was the first time ever addressing the issue. That's what they said in the oral arguments. Judge Widget, he asked, did the Commonwealth Court ever address this issue? And it was no. And he said, well, we don't have to follow Superior Court's ruling. He said, no, it's according to jurisdiction. court. But this case wasn't precedential. It's a non-binding memorandum. And it wasn't enough conflict within the two courts that I think would present a substantial question. And I thought about it, and I asked my clients, and they, you know, Jarvis said, don't chase ghosts or something like that. But I thought really hard about it. I just didn't see any cases. I didn't see enough cases to make a compelling argument to the Supreme Court, because the Supreme Court is tough. I got one case there and won, but I had helped the Jules Epstein. He was the heavyweight. But it was most cases are Supreme Court stuff. So,
Thanks, Mr.
all right, I'm sorry.
No, thank you.
Oh, right, sorry. Do you have any personal knowledge of any other attorneys, without saying their names, that failed to appear in arbitration, even though the cases were remanded to arbitration?
Yes. Yes, I've seen it before.
And what was the outcome, if you can recall?
They just got a trial. And I'm not gonna say any names, but I've talked to senior lawyers about this, and they thought it was absolutely ridiculous that the case were not scheduled for trials after we filed the 3151 motion. They thought it was absolutely absurd. And yeah, I talked to older lawyers. I talked to lawyers who actually just think, okay, just appeal. Don't go to arbitration. Nobody care about that. I mean, if you're asking for more, what they can give you, what do they expect you to do? So yes. And if you look at the Hall case, the court acknowledges that this is quite common actually. Yeah, it's on. I think it's on page. I don't remember. It's on the second page of that case. But I'm not the only lawyer. And just so I'm clear, I wasn't trying to just spite the court. You're not going to win in court, and you need the courts, especially as a lawyer. So I'm not trying to just put my thumb up to the court. Not at all. My clients did not want to arbitrate their case for less than the amount that they were asking for in the arbitration statute, and the rules, when you read them, it's very clear. And I didn't want to spite spite the court. Was not trying to do that. My clients did not want to arbitrate their case for less than the amount, and they seen the arbitration statute and they read it. And I remember my clients were saying, "Why are they treating you like this? Why are they making you jump through extra loops that nobody has to go through?" So I'm sorry if I rambled. I hope I asked your question.
You did. I have a follow-up question. Did you have, and you may have answered this already or spoke about it, are there other cases that you handled in which you did not go to arbitration and did in fact go get a trial after?
I never in my life dealt with anything like this, and ODC talked about the case management memo, and I guess maybe I should not admit this, but look, I'm here. There was cases where we settled or otherwise favorably resolved, and I think I even missed the case management conference, didn't even file none of that. Like this, I'm new to this whole case management issue is I never heard it before. I never said you determine the value of a case based on that. So I know situations, even in federal courts, settled cases or where we didn't even fill out the intake form that you're required to fill out. We just filed a complaint. We so focused on making sure the legal basis for the action is sufficiently set forth in the complaint, so the complaint is sufficient. As far as the case management form, and I'm not saying I don't file case management forms or otherwise comply with the procedures I do. It's just that I've never heard somebody not putting the exhibits on a case management form to be dispositive of the outcome of a complaint.
Thank you.
I just want to follow up about the other lawyers that you testified that you knew about who didn't attend arbitration hearings and then still got their jury trial. Did you know about any of those before the arbitration hearings were scheduled in Miller and Myers, or only did you find out after that?
No, I knew before, because when the cases were put into arbitration, in fact, I remember I was asked, well, what happened at the pretrial conference? Well, maybe you should have did better discovery. I remember, I think Mr. Elmore asked me that, and I said, we didn't even get that far. And they determined the value of the client's cases at that, shortly after the case management conference, with no evidence. We didn't even get the pre, we didn't even, just technically you can start discovery upon filing the complaint. But we didn't, I told him we didn't even get that far. He said, how is that even legal? So I've talked to other people, and the consensus, at least from my perspective, is, we haven't even heard of nothing like this before. Just file your appeal, you should be fine. That sounds crazy. And Mr. Elmore did say, isn't that a recusal issue? How is he determining the value of the case without, that's a problem. And then I remember explaining to him about the Peyton matter. And we had a discussion about that.
Mr. Bell?
I do not have any questions, thank you.
Yes. Okay. Either, Ms. Sammons, do you have any follow-up questions from what the
I do not.
docket?
No follow-up questions, counsel.
Hold on a moment. All right, Mr. Bell, you're excused.
All right.
Okay. I have a feeling that the exhibits might take us a few minutes when we get into it. So I'm gonna say that we'll take our lunch break now. When we get back from lunch, we'll do the exhibits, and then I presume you'll rest. And then we'll hear argument as to whether there have been prima facie violations of any rules. And so we'll do that after after both sides have rested. Ms. Henderson?
Yeah, that works for me. How long did you want to take for lunch? It's 12:33 right now.
How long would you all like, bearing in mind that you might be getting ready to argue a little bit? So if you want to take a little bit longer than usual, then
We take 45 minutes.
is that fine with you, Mr. Duckett? All right, so let's do 1:15.
1:15? Okay.
15, I said that right.
We alive.
Okay.
Sorry.
All right, Mr. Duckett, I think you wanted to move some exhibits.
Yes. Respondent would like to move and admit exhibits 1 through 35, 37 to 40.
Wait a minute, wait. 1 through 35.
Yeah, let's take it slow.
Okay.
1 through 35.
Yes.
Go on.
37 through 42. Let me know when you're ready.
Yeah.
45 to 49.
Okay.
51 to 60.
Okay.
And 62 and 63.
63 is the letter from Judge Wallace, right?
Yes.
Yeah, okay.
And I believe we already addressed our joint.
Yes.
The joint exhibits from, okay, so Ms. Ammons, I know you probably have some objections, so what's the easiest way to
Okay.
go through
I
here?
will tell you which exhibits I had objections to.
We'll cross-reference, all right, so you're got what Mr. Duckett is offering, and which are your objections?
Okay, my objections are 22, 23, and 24, because that involves the state court matter.
First, just the numbers.
Okay, 22, 23, 24,
Mhm.
31, 32, 33, 34, and 35.
Okay,
And 57.
okay.
This, you're not introducing 44, correct, Mr. Duckett?
He did not say.
Okay, I just wanted to make sure, because that was one I was objecting to. I just want to make sure.
Okay.
So those are the ones I'm objecting to.
All right, so, we're gonna go through this, make sure that we deal with each of these. So exhibits 1 through 21, there's no objection.
Correct.
So those will be admitted. Now let's talk about exhibit 22. Let us get to that. Oh,
I think they're in the other.
they're in the other one.
We might need some base numbers too.
Four 61.
We've got the table of contents.
Yeah, 461.
461.
Oh, I see that, the page numbers on the table of contents.
461, that's where it was.
Um,
460, sorry, yeah, 461.
All right, and Ms. Ammons, what is your objection to exhibit 22?
My objection is that they're irrelevant to these proceedings. This is concerning Ms. Murphy's state court matter. It has nothing to do with the federal court matter at all, so it's irrelevant.
Okay, Mr. Duckett, what's the relevance?
Both Murphy's cases were in state court and federal court. Same attorney on both cases, Mr. Bell for the plaintiff, Ms. Jankowski represented for the city, or the attorney for the city's law department. Because these cases deal with the same issues, deal with the same parties, and give a complete context of what happened with these cases, I believe they are relevant, especially when my client is making representations that there were, I guess, false statements made, essentially.
Was exhibit 22 referenced in Mr. Bell's testimony?
Yes,
Okay, I didn't recall that.
I can,
Same thing for 23 and 24? Mr.
Correct.
Bell, did he testify?
I'm sorry. I thought you were talking.
No, I'm just trying to figure out if these were referenced in testimony.
yes.
And I think I objected to that testimony because I
Okay.
said it was irrelevant.
Right, okay. So, this is why I always like it when people move admission of exhibits soon after as opposed to at the end of the case, but we'll deal with it. Okay, so, so just articulate a little better for me, Mr. Duckett, why the state court case is relevant to the, I do now remember this testimony, I think it was brief, but what that has to do with the alleged conduct relating to the federal case.
One, it gives a context of everything that happened with regard to these cases, but I think one of the big things, which is part of our defense, especially when it comes to equal protection violations, that it shows essentially that with respect to the violations that are brought against Mr. Bell, that there are other parties involved that he put on notice, that he put the courts on notice about making false statements, and essentially with our selective prosecution, that with them being aware that, and him being similarly situated, being in the same case, both being lawyers on the same case, I believe is relevant. With that perspective.
All right, well, I think the probative value seems very limited in this, but I also don't see any significant prejudice from it. The committee's able to give it the weight that it deserves, and these probably are things that we could take judicial notice anyway of because they're filing, so I'm gonna overrule the objection and admit it, but that's without prejudging whether this has any probative value in these proceedings. there's no jury, so we can weigh the evidence. So 23, 22, 23, and 24 are admitted. Let me get the next binder. Well, so then from 25 to 30, there's no objection.
Correct.
Right, so 25 to 30 will be admitted, and let's take a look at Exhibit 31, which is page 637. Right. All right, so 637. All right, in my binder, Exhibit 51 has 3 pages. 638 and 639 are a news article, and 640 is a response for criminal record check, which doesn't seem part of the exhibit. Maybe it's just in my copy, but
You're looking at
31.
31.
but
Let me check my exhibits then. I see.
sorry about that, I misspoke. So Exhibit 31,
Yeah.
I see on page 640, it looks like a different document altogether, and I don't know if that's a mistake or if it's part of the exhibit. So maybe, Mr. Ducker, you can just clarify on that.
That is a mistake.
Okay, so we're gonna, so Exhibit 31, which I recall was referenced in the testimony, is just these 2 pages, 638, 639,
Yes.
right? And what's your objection, Ms.
My objection 1 is irrelevance, also hearsay. I don't know if Mr. Duckett is offering this as the truth of the matter asserted. And if that's the case, I definitely have an objection to that. It's not relevant.
Mr. Duckett?
I believe it goes to my client's state of mind, especially with Mr. Payton being a party in the minors case, and that case being before Judge Anders. So when he filed his recusal, he had this information. Well,
Well, he testified about his experience with Mr. Payton's case, and I don't know that this article goes to his state of mind as opposed to the underlying events that he personally witnessed and testified about go to his state of mind. But I do recall, wasn't this exhibit used with Judge Anders?
yes,
Okay.
And I think I objected to that as well.
Right, and I think I overruled the objection as to the questions because it was offered not for the truth of its contents, but to demonstrate that that ruling had garnered significant
Don't hide the
publicity, which I
fruit. What's wrong
understand to
with
be
you?
part of
Give it to me.
the respondent's case. So, so the objection's overruled, but it is not admitted for the truth of the contents, only for the fact that the ruling in the Payton case was publicized. So that's Exhibit 31, and now let's move to Exhibit 32, which is the affidavit. Ms. Hammonds?
Again, relevance. This happened in Mr. Bell's underlying case, Mr. Bell's case against the city. This has no relevance whatsoever to the charges in the petition for discipline. Mr. Bell testified to it. I don't see how this document is any probative value. He testified to it, just like 33 with the apology. I don't see what the relevance is to this.
Well, I think as I heard the testimony about this before, that it relates to the claim of selective prosecution. And while I think its probative value there is very limited, it was a publicly filed document. And this is an argument that Mr. Bell is making in this case, and I think the committee is able to give it the weight that it deserves. So objection overruled. We will admit Exhibit 32 and move to Exhibit 33, which I take it is the same issue. And so same ruling, will admit Exhibit 33. Exhibit 4 is the transcript of 34 is a transcript of this proceeding. Actually, it looks like, Mr. Duckett, what is the relevance of this transcript?
Part of the defense that we have is that Mr. Bell has been essentially targeted by judges, that judges have misapplied, or I want to say ignored the facts when it comes to some of these proceedings. And I believe that when he says that's happened with Judge Rubino, it's happened with Judge Schulman, and I believe this is another example with Judge Prater, where we have John Poyle, someone who he's tried a case with, I believe, Mr. Hubbard.
Okay, let's just pause for a moment. So
All right, that pause reminded me of something. Michael, it's June 12th right now. I think we're really close. I think that if Judge Eric is coming back, he's coming back any day now, or now.
I'm going to say that the treatment of Mr. Bell by judges is different from the claim of selective prosecution by ODC. And this transcript has very, very little probative value as to the selective prosecution by ODC. I also think it's not particularly helpful to the argument that you want to make about that. This is a collateral issue even to the defense that you are raising about selective prosecution. So
I do have another reason why I believe all of this happened prior to the Millers and Myers matters, where my client asked Judge Anderson to recuse himself because he believed that the judge was not complying with the law, or essentially being objective when it comes to evaluating the facts. And I believe this goes to his state of mind when he filed that recusal as well.
I'm going to sustain the objection to Exhibit 34. So Exhibit 34 will not be admitted. We'll move to Exhibit 35, which is Judge Prater's order. Are you really objecting to this, Ms.
I don't see the relevance.
I don't think it helps Mr. Bell very much on this argument, but it's an order of the court that is on the public docket. It explains the court's ruling on this issue, and I'll allow it in. again, as with these others, that doesn't prejudge the extent to which it has probative value for the committee. So we'll admit Exhibit 35. And then Exhibits 37 to 42, there's no objection.
There's no objection.
So those will be admitted, and 45 to 49, there's no objection, correct?
No.
So those will be admitted. 51 to 56, there's no objection.
No.
So those will be admitted. And then 57
1013.
is on 1013.
I have an objection to that.
Yes. That's why I stopped there. Um, Um, so I'm not inclined to admit this, Mr. Duckett, because I don't think that it is very probative of the selective prosecution claim, including because I don't think the record is clear on either side what statements the complaining attorneys made about Mr. Bell. And we only really get to this as an example of selective prosecution if the statements were actually made. And so this affidavit doesn't bear on what statements those individuals made to ODC. It's a response to statements that are understood to have been made, but I don't think we have in the record anything about what statements were actually made. We have the DB7, which doesn't identify the source of the information. And then I think we have an absence of evidence. And I'm also sensitive to the Rule 402 concerns with admitting a document like this into evidence. And so even though you could maintain it confidentially, I think because of the limited probative value, it doesn't need to be in the record. It's not going to be helpful to the committee in deciding this case or even in ruling on the selective prosecution claim. So I'll sustain the objection as to Exhibit 57. And then 58 to 60, there's no objection. Right, Ms. Evans? 58, 59, and 60.
60, I have an objection.
Oh, you're right, I'm sorry. 58 and 59, there's no objection.
Correct.
And then Exhibit 60, yes, this report. So you did object to the testimony
I
about
did.
this, and my ruling then, subject to the foundation being laid, which it was, Mr. Bell testified that he had seen this prior to making the statements in the motion to recuse, and he testified that this factored into his state of mind in making those, which I think in order to meet your burden on a Rule 8.2 or 8.4 violation, we need to understand the basis for the statements that Mr. Bell made. And so this is what he's saying was part of the basis of that. You
I-
look
yeah,
like
but-
you have something to say about
Yeah,
that.
because I think that's Mr. Bell's burden. My burden is to prove that he made the statements and that Judge Anders came in and he denied that he was racially biased. Then the burden shifts to Mr. Bell, and I have case law on that.
No, I understand the burden shifting
Yeah.
framework. I guess to say it more artfully, right? It is Mr. Bell's burden to establish the reasons why he made the
Correct.
statements. And he has testified that this report was a reason why he made the statement. And you might argue, Ms. Ammons, that it doesn't justify the statements that he made, but he's allowed to put in evidence about why. And he testified that he had seen this report, and this was one of the reasons why he made the statements that he did. Everything else is just argument about how much weight to give that. But I'll overrule the objection and will admit Exhibit 60 for that purpose. It doesn't go to the truth of the matters contained in it, right? It's only admitted for the effect that it had on Mr. Bell when he made the statements about Judge Anders later on. All right, then Exhibit 62 and 63, there's no objection, correct?
I have no objection on 63, but 62 is the same argument that I made for 60.
Yeah, well, let's. Oh, okay, so you know what, I think I hadn't written down, so you were objecting to 60 and you're objecting to 62. 60 we admitted.
Correct.
62 is, what page is that on?
1121.
11,
So that's one.
1. Oh, this is that collection of news articles. There was not a foundation laid for these documents. Mr. Bell testified that he was aware of some of the issues described in the articles. He didn't testify that he had seen these specific articles. Most of these weren't even discussed during the testimony. And so, unlike with the other document where there was a foundation laid about its effect on Mr. Bell's state of mind, these don't meet that same standard. So I'll sustain the objection, and we will not admit Exhibit 62. How about 63?
63, I have no objection. That's the judge's letter.
That's the judge's letter.
Yeah, I have no objection, of course, to that.
Okay. All right, so we will admit Exhibit 63.
I do ask that, because we talked about this earlier, to take judicial notice of the Carroll versus Anders memorandum that was filed on March 25th, 2020.
Any objection to that?
Yes.
What's the objection?
One, I don't believe a foundation was laid as to when my client became aware of this memorandum. And I believe that when it was discussed and
Guys, Bobby just made a statement about a person who committed a crime. She unintentionally hit a motorcyclist, and I don't think he lived. She ran a red light, so she wasn't trying to hurt anybody. She just ran a red light. It was an accident. Bobby said, this is what he said: not intentional, so don't think homicide would be proper. He didn't go for put her in jail for 100 years, throw away the key. That's, Bobby, that's progress. You're progressing, you're growing. I'm so proud of you.
in the examination, Ms. Ammons described this as a final memorandum. The way she described it is not the title that it has on it. It's the same title as one of the exhibits of this memorandum. So I believe that the testimony on didn't lay a foundation for that judicial notice.
And Mr. Bell did testify that he saw this when he did his investigation. He testified to
That's
that.
my recollection of the testimony also, is that he did testify that this was a document that he saw when doing the investigation. You can obviously make whatever arguments about it, and I'll leave the characterizations of this document, what it shows, to you in your briefs, and we can consider it. But there was a foundation, and whether it's judicial notice or admitted, I think we should just admit it as an exhibit to keep it simple, but I think it has the same effect because it's documented.
Thank you, and that's gonna be listed as ODC 59.
ODC
59.
59, okay. As we talked about at the time, and Ms. Ammons didn't object, the committee can take judicial notice of any of the filings in that case, including the ones that postdated this one. And so if there are arguments either of you want to make in your briefs about subsequent decisions in that, then you certainly can. I'll say, just speaking for myself, I don't know that that would be the best use of the pages available to you in your briefs to do that, because I think it is a collateral issue, but I will leave it to all of you to focus on what you think are the most important questions. Anything else with exhibits?
I have nothing further.
Docket?
Nothing further.
Oh,
Oh,
59
I have
hasn't-
59 up here. I didn't give it to you yet. Do you want
Okay,
that?
I'll write this.
No, I just had it over here because we,
Make sure we get it after.
Right.
and-
I will make sure that it's included with
Okay.
date stamps when I send all the exhibits. And I request that Mr., I don't know if you want to do this, Chair, because Mr. Duckett did provide his exhibits to you via, I guess, the internet, whatever it's called.
Email.
Email, yes. I couldn't remember the.
One massive PDF.
If he wants to send it again with, well, you know what, the court reporter will have the official exhibits when we send it to her with the ones that were admitted into evidence, so I'm not gonna mention it, I'm sure.
Well, right.
That's why I wait until after the hearing so I can send.
Yeah, but Bobby, plea bargains aren't always the courts being lenient. You take a plea when you don't go to trial. So let's say I went across the street to that neighbor right over there and I punched her right in the face. Let's say I did that. Okay? And the police come and they arrest me. And I'm like, yeah, I'm guilty. I punched her right in the face. And I'll do it again. I punched her in the face. Well, I'm not going to trial. I'm not going to make the court go to, a full trial to see if I punched her right in the face, because I admitted it. I admitted I punched her. So I would plead guilty to that. That doesn't mean leniency all the time just because it's a plea bargain. A lot of the times, yeah. If I plead guilty to punching her in the face, maybe they'll get rid of the fact that I drove my car over there real fast and was speeding. But, I don't know. Most of the time, you're right. Plea bargains, they get a deal. But not all the time. Plea just means no trial.
The exhibits that have been entered as evidence.
Yeah, I think it would be helpful, Mr. Duckett, now that you have the rulings on the exhibits that are in and not in, for you to, at your convenience, submit to the committee the set of exhibits that were actually admitted. That way we don't inadvertently look at a document that wasn't offered into evidence or wasn't admitted. So that doesn't have to happen right now, but I think it would be very helpful for us in writing it, not to have to constantly cross-reference, did we admit this exhibit or not?
My coffee's here. I'll be right back.
Great. That's it on exhibits?
Yes.
Okay. Any other, so Mr. Duckett, are you resting?
Yes.
Okay. Anything else, Ms. Ammons?
I have nothing further.
Okay. So,
Because I believe I enter all my exhibits 1 through, well, now it's 1 through 59. Enter all my exhibits.
I think you're right. Okay.
Yeah.
And we have those joint exhibits from
Correct.
this morning. So I think the record is complete there.
And did I say that on the record, how many, 1 through 6? J 1 through 6.
I think we spent a lot of time on the record this morning with
Yeah.
those. I think
I just wanted to make sure that I said it on the record, J1 through
Yeah.
J6.
and I think you
Thank
read
you.
out their names as well.
Yes.
So, okay, so this is the stage of the proceedings where we will discuss whether to move to the 89-151 phase. And I just want to talk for a minute and then maybe ask a question and then hear argument from each of you about the rules. So what 89-151 provides is that evidence that goes that's relevant to the type of discipline to be imposed is deferred, so that we hear the evidence first about whether there's a violation, and only if there's a showing do we progress to the to evidence about the type of discipline, because that by definition isn't relevant to the question of was there a violation. And the rules give us several options. We can make a finding that the evidence establishes a prima facie violation of at least one of the disciplinary rules alleged in the petition. We don't need to specify which rule that is. We just need to say that we've made that finding, and then we would, this is procedure D1, we would immediately proceed to the consideration of additional evidence only relevant to the type of discipline, basically aggravating or mitigating evidence. Or if we don't make that finding on the record today, then we would have briefing and findings that we would issue on the question of misconduct. And then after those findings and conclusions, receive written submissions by the participants within at most 10 days of that aggravating or mitigating evidence. There's also a provision for if we had to reconvene the hearing, which I don't think would be ideal. So the question I have, just as we listen to the argument on the prima facie violations, is I know Ms. Ammons, you said yesterday that your 89-151 evidence was just written. You had exhibits that you wanted to offer.
I had exhibits that I intended on offering into evidence. I am no longer offering those documents into evidence.
I understand. And there won't, but you wouldn't be calling any witnesses.
I am not calling any witnesses if we
Okay.
proceed.
Okay. And Mr. Duckett, what I'm just trying to understand is any 89-151 evidence that you might have, is it just written submissions, or do you have any witnesses that you would be calling if we reach that part of the proceeding?
No witnesses.
Okay. Would you expect to have written submissions on 89-151?
Possibly. Yes, I'm not sure. Like you said, it would only be relevant if there was a violation.
The face that Ms. Ammons is making makes me think that she's surprised by that answer, so.
I'm surprised by that answer because usually when we have 89-151, that evidence is presented at a hearing, not in written submissions, in the brief or anything, where I have an opportunity to look at it and if need be, have any rebuttal evidence or anything, so.
And is this, I believe, Ms. Ammons, you said before, you exchanged with Mr. Duckett the documents that you would.
Which I had intended, if I was, I said we may
I understand.
use it,
But
but yeah.
Mr. Duckett, did you share any exhibits with Ms. Ammons that go to 89-151?
Not to go to 89-151.
Okay. I mean, there is this procedure in subsection D of 89-151, which, as I understand, might be rarely used, but it exists. And I just wanted to understand kind of what that was going to be. So
You said subsection D?
subsection D2. So D1 is what I often see, which is you make a finding on the record and you immediately proceed. But the rule doesn't say that's the only option. It also gives an option where we can receive it in writing, and particularly where there is no testimony that's going to be offered. That's a more plausible option than if we were going to have to reconvene and hear more testimony and all of that. I suppose there would also have to be an opportunity for some limited briefing as to the recommended discipline if there was a finding of a violation. So we have to figure that out. But anyway, I think I know what I need to know about whether there would be witness testimony at 89-151, and the answer is no from either side. So that's been, at least we're clear about that. Okay. So what we should do then, and we'll hear first from Ms. Ammons, you don't need to argue your whole case here, because there's going to be post-argument briefing for that. So I'd encourage you to focus on the issues that you think are the clearest for us if we were to make a finding today to be able to reach that finding. And obviously that's without prejudice to you making whatever arguments in your briefs you want to make.
Well, usually
I don't want people to think they have to make every argument at this stage, because
I understand, because usually I reserve my closing for my brief, but since the panel wants a brief, I'm going to try to be brief.
Yeah,
okay.
and I guess I'll just make one comment, and hope, just because of what I think would be helpful for us. Reading the petition for discipline, it is organized in a way that I think is typical of how these are organized. I might recommend a different approach in the future, but it's because it's organized by case. Then there is a list of alleged facts, and then there is a list of rule violations. And I personally find that style difficult to follow, even though I know this is what is always done, because it doesn't clearly identify, particularly in a case like this, where the rule violations in some cases involve specific statements that were made to courts or otherwise. To not have that clearly laid out in the petition makes it a little bit more difficult for us to identify, well, if they're saying there's a 3.3 violation, but I don't know where in the last 10 pages they're saying was the 3.3 violation. So as you talk to us today, and then later as you do your briefs, it will be helpful for us so that we don't have to guess about, it's this statement that was made in this exhibit. That's the basis for the violation of this rule. Just to try to make it easier for us, and therefore easier on you as you're making the arguments.
I understand. So I was not planning on discussing all the rule violations. I plan on discussing specifically, which I want to lead off on, is Judge Anders and the allegations against Judge Anders. ODC's position, well, first of all, we believe that we proved all the rule violations contained in the petition for discipline by clear and convincing evidence, which is the standard of proof in our proceedings. Respondent level baseless claims in his petition for relief that Judge Anders intentionally misplaced the Myers civil matter into compulsory arbitration as a result of his personal bias and animosity towards Black litigants.
I want to just make sure we're following along, but it'd be helpful if you can tell us what exhibit and where just because I think for these rule violations about Judge Anders, the specific language matters a lot.
Okay.
So I just want to make sure that at least we can follow along with you about the language and where it is so that we can best understand.
Okay. So his petition for relief, I'm talking about his, and I have to go down my exhibit list because I wasn't planning on doing this.
I understand.
Okay, his motion to this is the, Myers case. So his motion to recuse Judge Anders, which is ODC 44, And also his motion for relief of judgment of non-pros is ODC 46,
Okay.
where we allege that, which I believe that we proved that respondent made baseless claims in his petition for relief that Judge Anders intentionally misplaced the Myers civil matter into compulsory arbitration as a result of personal bias and animosity towards Black litigants.
Can you tell us where the intentionally misplaced language is?
Okay, I have to look at the
Sure.
actual exhibit.
Yeah, that's fine. I mean, I'm being precise about this because the rule violations that you're talking about for the Judge Anders comments turns very specifically on the language used, and so I want to make sure we understand.
Okay, so in his, I'm just gonna go through the plaintiff's motion to recuse Judge Anders. Exhibit 44. Number 3, he said that in the Millers and Myers, all 3 plaintiffs are Black, accusing PPD officers of official misconduct, and all of the defendants are white.
Was that a true statement?
This is what, I'm reading from his plaintiff's.
Right, but I'm asking you, which are the statements in Exhibit 44 that are the basis for discipline?
Okay, let's go to number 7. Judge Anders' arbitration orders in Miller and Myers has the appearance of being biased entirely upon a subjective belief that a Black plaintiff's pain and suffering is not worth a jury's attention, in addition to appearing as a clear signal that he will disregard a plaintiff's basic rights to appease the Philadelphia Police Department and the Philadelphia Social Security, Philadelphia Solicitor's Office. Also, number 8, Judge Anders' arbitration orders in Miller and Myers has the appearance of being motivated by racial hostility towards non-white people. To be sure, it appears that Judge Anders denied the Millers and Myers plaintiffs their rights to a jury for the purpose of protecting white Philadelphia Police Department defendants in those cases, because he is requiring the non-white defendants in this case to face a jury, which makes no sense. Okay, and then it says that number 9, it appears that Judge Anders' unlawful arbitration orders in Millers and Myers are motivated in large part by a design to retaliate against the undersigned counsel and Jarvis Payton. Let's see. Then he said, which Judge Anders completely denied under direct, he says on number 12, however, begins with however, Judge Anders has confirmed that he may be illegally working for the defendant's attorney's office by his intentionally wrong decision to grant a frivolous and untimely motion for extraordinary relief in York versus Cannon. As I said, Judge, if you remember Judge Anders' testimony, I questioned him about that, and he said that was completely false. Then, number 13, he said that since it appears that Judge Anders is intent on bringing disrepute upon the judiciary with his overly defense-friendly rubber stamps to put the undersigned in his place for the audacity to seek justice for police misconduct victims, it appears obvious that Judge Anders is attempting to sabotage all of the undersigned cases to which he has currently assigned himself without coincidence. And as you recall, I asked Judge Anders about that paragraph. I also asked him in regards to how our cases assigned to him. And because respondent said that he curiously assigned cases to himself without coincidence. And Judge, as you may recall, Judge Anders said He's the team leader. He was the team leader for 2019. So all the cases automatically went to him as team leader. Also in his motion for relief of judgment, which is 46, and I have to find a paragraph. He said that number 4, during the case management conference, defendant's counsel requested the court staff ask Judge Anders to deny all of plaintiffs in this case. Judge Anders said that was completely false. And in their Miller,
On paragraph 4, paragraph 4 is about defendant's counsel request to the court staff at a proceeding that Judge Anders wasn't present at, right? Judge Anders testified about what he was told.
I asked Judge Anders, did anyone ask him to place these cases in arbitration? And he said no.
That's different than what paragraph 4 says though, right? It says during the case management conference that Judge Anders wasn't at, defendant's counsel said something.
And I understand that, but what I'm saying is, based on this paragraph, I asked him, did anyone ask you to place these cases in arbitration? And did that influence your opinion? So I think that goes to the gist of number 4. Number 8, which is on 1745. In this case, he talked about Judge Anders' brother and how he was being sued in federal court for using his police powers to racially discriminate against a black man. In number 9, it said that as a result of it appears that because of Carroll versus Anders, this case was intentionally misplaced in compulsory arbitration as a result of personal bias and animosity towards black litigants stemming from Judge Anders' brother being accused of racial profiling a black person. I asked Judge Anders during his testimony, first, was the Anders that was in this case, was that his brother? He said yes. Did you know about your brother's case? He said no. I said, would your brother's case where he was being accused of racial profiling a black man, would that have affected your opinion or your decision to put the case in arbitration? And Judge Anders said no. Do you want me to go through the whole thing again? I mean, that's some of the examples, and that's the reason why I believe ODC proved RPC 8.C with A and C.
8.8.
RPC 8.2A, which states that a lawyer shall not make a statement that the lawyer knows to be false or with reckless disregard as to the truth or falsity concerning the qualifications or integrity of a judge, I can't even say that name, officer or public legal officer or a candidate for election or appointment to judicial or legal office. There's case law. Office of Disciplinary Counsel versus Richard Joseph Silverberg that specifically goes to this notion of attorneys making false statements against judges. And it says in Silverberg's statements about Judge Roberts were false. And Silverberg knew they were false at a minimum. Silverberg made the statements with reckless disregard as to the truth or falsity. Mr. Bell was reckless. He had no evidence except for his self-serving statements. He brought no other evidence except for his statements. He didn't have any witnesses saying that Judge Anders was biased. He didn't have his client come in. At one point he said, I don't understand why my clients weren't brought in to discuss things. I didn't have to bring his clients in. He could have brought his clients in. So Silverberg says, Silverberg presented no evidence showing that the allegations were true or that he had a good faith, non-frivolous reasonable basis for believing the allegations were true. It says, he also said in Silverberg's false statements were material because they served as a basis for the recusal motion and amended complaint in that case. The board further states, after it was proven that the statements were false, and it was proven in this case through Judge Anders' testimony, that the burden shifted to Silverberg, just like it shifts to respondent. That his allegations are true or that he had an objective, reasonable belief that the allegations were true based upon a reasonably diligent inquiry. Mr. Bell testified he did no other investigation to determine if Judge Anders was actually biased. He actually said, I don't know that man. It was based on, because he transferred these cases to arbitration. And the litigants happen to be black. So I believe, for the purposes of the hearing committee, that we have at least one rule violation in 8.2A.
So can you give us the
site?
citation for Silverberg?
Sure. It's number 172 DB 2003. The D board report is 31125. The Supreme Court order is 51625. That's the site, because it was just recently decided last year.
Okay. I think I remember.
You remember this case?
I wasn't in that case.
Oh.
But I remember reading about the case.
Yes.
And did you say that the statements were made in the context of a recusal motion?
In Silverberg it was. Mm-hmm.
Are you, other than Silverberg, are you aware of any cases involving recusal motion statements?
This is my case I'm hanging my hat on. I'll find other cases, but right now, this is the case I'm relying on. But I will definitely find other cases, and I will definitely put it on my brief.
Yeah, I did have this. I was wondering about that, because some of the cases I've seen occur in other contexts, and I thought this one was a little different from some others because it's in the context of a recusal motion, but we'll take a look at, maybe we'll look at Silverberg and take a break just to see.
So I don't know if you want me to go further, but for the purposes of the hearing committee, that's at least one rule.
So 8.2A, and you've identified various statements about that. All right, then you had another one you were going to talk about, right?
I was going to have another one, but
All right, well, maybe.
I think for the purposes of the hearing committee, that one is not the most important, but that's something that is clear evidence, even though I think all the other ones are clear and convincing. This is clear and convincing evidence that respondent violated this rule.
And so my understanding of the burden shifting framework that the Pennsylvania Supreme Court has laid out, including in, I think, ODC v. Zurich, right?
Yes, that was the first case.
That there's an initial burden that ODC has to establish that the statements are false.
And I established that by Judge Anders' testimony.
And then the burden shifts to the respondent to show that either they're true or that there was a basis for making those statements. I guess one question I have about that.
Oh my gosh, what if he says why? He won't, but that would be very funny.
Sorry.
Say why. Just say why. Say it. One question. Why?
how does that affect
Brad, you were this close, but no.
the prima facie issue? So, in other words, because of this burden shifting framework, right, in order for us to find that there's been a prima facie showing of a rule violation, we have this multi-part burden shifting test, right?
Mhm.
But before we get to 89-151, I think there's some
It's your determination whether or not respondents, as the board stated and the court affirmed, that there has to be a reasonable basis, a good faith, non-frivolous, reasonable basis for believing that the allegations are true. The only thing Mr. Bell testified was there were black litigants. In Miller, he was a black litigant. And a case that Mr. Bell was involved in 2015, 2016, where before he was an attorney, he helped someone out. He helped Mr. Jarvis out. Judge Anders testified, he doesn't remember names. He didn't realize Jarvis was the plaintiff in the Myers-Jarvis matter. He said he doesn't even remember, if I'm not mistaken with his testimony, that he didn't even remember Mr. Bell. So, and he deals with thousands and thousands of complaints each year. Judge Anders said the basis for him putting the matter in arbitration was based on the report that he got from Eric Orvick, from the memorandums that was filed by Mr. Bell and Mr. Hubbard. He used that to determine that the amount in controversy was $50,000 or less, and that's the reason why he put it in arbitration. It had nothing, he didn't know the race of Mr. Miller. He did not know the race of Miss Myers. He couldn't even remember that Mr. Jarvis even appeared before him, because it happened maybe 4 or 5 years before the case was even filed. So Mr. Bell's testimony is frivolous, it's not reasonable, and he based it on reports from, the report from the First Judicial District that Judge Anders' name didn't even appear in those documents at all.
What do you make, Ms. Ammons, of, or I'm sure we'll be hearing this argument from Mr. Duckett shortly, but we heard it in Mr. Bell's testimony, the significance of the word appears in some of these statements, that he was, as I understand his testimony, focused on the appearance of bias as opposed to actual bias, and that when he said it appears that he is biased in this way, that is different than just having said it. I want to get your perspective on that.
Of course, and I have your answer. Reckless.
I have been waiting for this question this whole time.
In the Silverberg opinion, it was reckless. He had no basis whatsoever to make these allegations against Judge Anders.
Son of a bitch. She didn't answer the question. She didn't answer the question at all. Legally, what is the difference between him saying this judge appears to be biased than this judge is biased? Like, not why is those two phrases different? That's not what I'm asking. Legally, what is the difference? That's what we need to know for this.
Reckless. I have case law on that even if you subjectively say, he's racist, you have to have a non-frivolous reason that's not reckless. Anyway, this was a court pleading that Mr. Bell made these allegations against Judge Anders, a jurist who has never been accused in any appellate decision that he was racially biased at all. So, at the minimum, Mr. Bell's conduct was
That
reckless.
doesn't make sense. Oh, he can't be. He can't have murdered that person because he has never been accused before of murder. That doesn't make sense. You didn't answer the question at all. You just didn't. It doesn't burn my buttocks because I don't eat it.
And so I understand that argument, but I think what I'm asking is a little bit different, which is
Monica, thank you for the cheers. Thank you.
in
Thank
terms of
you.
the statements that were made, to what significance is there a difference when a lawyer says it appears that the judge is biased as opposed to the judge is biased? And if there's not a difference, why?
I don't think it's a difference
Why not?
because of the reckless standard in here. I think that Mr. Bell's statements were reckless. He had no objective evidence that Judge Anders was biased at all. And again, going back to, then the standard is objective, it's not subjective. Going back to Silverberg, it says, the burden shifted to Silverberg to establish that his allegations are true or that he had an objective, reasonable belief, not subjective, objective.
Yeah, so let me just try one more time on this issue because I think this is the argument we're going to hear, and I want to make sure
I don't think it matters. That appears.
Because what I heard the argument as is, well, I was saying not that he was actually biased, but that it gives the appearance of being biased, which is maybe less of a factual assertion than it is a conclusion. And I don't know if you have seen any cases about that, but that might be something in the brief to be thinking about too, is that
I will be thinking about all this.
This appears issue, because at least I expect that's what we're going to hear in a moment.
Because let me read you one more thing that Silverberg said.
Hi, Walter.
The totality of the evidence establishes that Silverberg made the accusations against Judge Roberts knowingly or with reckless disregard as to their truth or falsity.
What was the allegation? What was it that?
Okay, I have to go back into the opinion.
We'll read it
Okay.
at a break. So that's okay. All right. Well, let's just stick with this 8.2 issue, and Mr. Duckett, let me hear what you have to say about 8.2.
Well, first, Ms. Ammons says that Mr. Bell's conduct was reckless, but it's a reckless disregard for the truth. That's the standard. That's what's listed in 8.2A, not just that his actions were reckless. Here, he has to establish that it's good faith, and I believe he does that by actually citing Carol D. Anders. He said that when he talked about that in the recusal, he actually had a case. The case was pending at the time, and I believe he said it gives the appearance. So I don't believe that he had reckless disregard for the truth when Ms. Ammons herself presented the docket. She presented memorandums. It's still a question as to when my client saw this. Was she mislabeled as the final memorandum? But I believe he has a...
And my name is Miss Ammons, I'm sorry, not she, but thank you.
Go ahead, Mr. Duckett.
Thank you. So I believe that shows good faith, non-frivolous. Now, when we look at why my client filed this motion to recuse and the history behind it, as Ms. Ammons stated, this came subsequent a ruling by Judge Anders that did not comply with the law. So when my client, when he produced this this motion for recusal, he had that as what I believe was the straw, essentially, that not so much broke the camel's back, that forced his hand. Prior to this, in Jarvis's case, Judge Ammons essentially had a trial, waiver trial, and he ruled that Mr. Jarvis was guilty. At that point in time, he made a factual finding. Subsequent to that, Mr. Jarvis filed for appeal. Now, we're not questioning whether or not Judge Anders, his finding of fact in that case was something that we need to look at intently. But subsequent to that, Mr. Payton filed an appeal. Judge Anders, who he himself says, I published books, legal articles, I've edited all bombs. He said judges are essentially experts in the law. He had an opportunity to read the law that was presented and his error in the law that was presented by Mr. Payton. And at that point, he denied Mr. Payton what the Superior Court said he was due. So at that point in time, not only did Judge Anders make a determination about the facts, he made a determination about the law that the Superior Court later said he was wrong. Now we fast forward to this case, and it's the same Jarvis Payton in front of Judge Anders. And when my client reads the arbitration statute, the part that says, in counties having rules governing compulsory arbitration, the plaintiff shall state whether the amount claimed does or does not exceed jurisdictional amount. The title of this 231 PA Code Section 1021, Claim for Relief Determination of Amount and Controversy, it says the plaintiff determines that. And here, a plain reading of the law is before Judge Anders, and Judge Anders says that doesn't apply. It says that the plaintiff shall determine that. So with that, he makes what he testified to as a subjective opinion. He said, based off the case management memo, I made a subjective opinion. If we look at exhibits J 1 through 6, which Ms. Ammons said she got after discovery was closed. If we look at the actual case management memos, the only information that's presented in there when it comes to the value is that the demand is in excess of $50,000. We asked Mr. Hubbard, I believe Ms. Ammons asked Mr. Hubbard, did he say the value of the case in his case management memo? If you examine him and listen to his testimony, he said no. The only numbers that were before Judge Anders for him to make what he called a subjective opinion was that the case was in demand in excess of $50,000. When you look at the other two exhibits which were produced by Eric Orvick, they say that the case original status was, I believe, jury trial, scheduled for jury trial. Then after the case management memo, they were saying that it says the current status and it says jury trial. So I'm saying that because Judge Anders said he used his subjective opinion, I think that solidifies my client's position and reason for having a good faith reason to file this motion for recusal. When it comes to
Mr. Duckett, just so we can focus, the Rule 8.2 violation, as I understand it, is not about having filed a motion for recusal. It's about statements that are contained in the motion for recusal. And so I think we should try to focus in on those. And, for present purposes, actually the one that I would like to have you focus on is in ODC 44, which is the motion for recusal in paragraph 12. It says, however, Judge Anders has confirmed that he may be illegally working for the defendant's attorney's office by his intentionally wrong decision to grant a frivolous and untimely motion for extraordinary relief in
It's 1726.
It's on page 1726. Thank you. Exactly. I think they found that they're just reading. Let me give you a moment to read that. And,
Well,
Now, I don't recall Mr. Bell testifying about that sentence, did he?
no, and I don't recall, Ms. Ammons eliciting testimony from Judge Anders about the veracity of that.
I definitely question him on that.
My memory is that Judge Anders said that he didn't know what that was about. Is that, well, we might have to go back and look at the transcript, but we won't be able to do that today. So, but what do you have to say about that statement, Mr. Duckett, in paragraph 12?
What I can say is that there has been no proof from ODC that shows a reckless disregard for the truth.
That's not the way the burden shifting works, Mr. Duckett. So ODC has the burden to show that a statement is not true. And this one doesn't say it appears that, right? It says Judge Anders has confirmed that he may be illegally working for the city solicitor's office, right, for the law department, by his intentionally wrong decision to grant a frivolous and untimely motion for extraordinary relief in York. So there's a couple of statements in there. One is that Judge Anders confirmed that he may be illegally working for the defendant's attorney's office, and that he made an intentionally wrong decision. So ODC's burden is to show.
That's a room. It's a room in Pennsylvania. Everybody's my size, so they don't need anything bigger.
So the statement isn't true, and then the burden shifts to Mr. Bell to show what was his reasonable basis in making that statement. And I don't know that we have in the record an explanation for that statement. I don't even, but just taking this point about that he was illegally working for the defendant's attorney's office, that is a very specific statement that, that was, my understanding from the testimony is that Judge Anders was employed by the First Judicial District. So what is the explanation, Mr. Duckett, for that statement in paragraph 12?
Before I answer that, you said before the burden shifts, it's up to ODC to prove that that statement isn't true. I don't believe that we actually elicited that with Judge Anders' testimony. He said he didn't know, but my client is saying he did so by his intentional wrong decision to grant a frivolous and untimely motion for extraordinary relief. There has been no testimony as to what that motion was, whether it was untimely, how it was connected. We have no substance there, and when Judge Anders said he didn't know, or is it, I don't recall, then I
don't think he said he didn't recall.
well, I know. I know he didn't say that, but.
He didn't know what your client was talking about.
Right. He didn't know. So if he did enter, I'm sorry, if he did make a decision or put something, it should be on the docket. We should have an order, some type of rule. We should have something that was presented to show, okay, this is what we're talking about. How does this apply? And we can elicit some testimony. But since this wasn't brought up to Judge Anders to show that it in and of itself wasn't true, and I don't believe that they've met the burden to say that this statement isn't true without showing the act. If he doesn't remember, then show the ruling, show the decision, and then refresh his recollection.
What about the part of the sentence, though, Mr. Duckett, that says that he confirmed that he may be illegally working for the defendant's attorney's office?
I think the word "may" is a huge three-letter word in that sentence. He didn't say he confirmed that he is. I think that is similar to. Using the term "gives the appearance."
Well, except that it says he has confirmed. So when did he confirm that he may be illegally working for the defendant's attorney's office? Because that's a fact. You're saying he confirmed it. So when did he confirm it?
So it would be, I think my client's good faith basis for making that statement has to do with the conduct in that case, the rulings in that case, the wrong
You're
decision.
talking about in York.
Yes,
There's been no testimony about what the rulings were in York.
I understand. I understand. However, that is where I believe his good faith basis for making that. And because that wasn't fleshed out by Ms. Ammons to show that it was false, and essentially dealing with the vagueness of this, I'm not even sure, it's 45-page complaint. She didn't try to prove that the statement was false to Judge Anders, so we didn't believe that, it elicited or needed more testimony to show that it wasn't reckless disregard for the truth.
Is it your position, Mr. Duckett, that Judge Anders had confirmed that he may be illegally working for the defendant's attorney's office?
It's my position that my client, he wrote that, but again, I think that word may is essentially that is his, I want to say, it's another opportunity for him to say it gives the appearance. He didn't say that he confirms that he has, he said he confirmed that he may be, and I believe he did that by the rulings that were made. And just to tie it in, those rulings there in York v. Canal, which haven't been presented, what exactly he's saying, the substance is not there. However, when we tie it to this case and we look at the prior Peyton case, I believe that he has examples of when the judge has had the law in front of him and he has ruled contrary to what the law says. So without diving into the substance, I don't think that ODC has proved that that statement is false.
Just give me a moment. And some of my colleagues might have some questions as well.
We're live.
Okay, thank you both for the helpful arguments, which, as I said, doesn't preclude anyone from making whatever arguments in their post-hearing briefs that they would like. So the committee is making a finding on the record that the evidence establishes a prima facie violation of at least one of the rules alleged in the petition for discipline. Now, Mr. Bell, that does not mean that we have reached a final decision about the rule violations in this case. That'll be contained in a report and recommendation that we issue after briefing, and it does not mean that we have reached a determination about any discipline that should or should not have been imposed. It is only a procedural, a ruling at this stage of the proceeding. That means that we can hear evidence from either side about factors relevant to the type of discipline. It doesn't prejudge what our ultimate ruling will be. It just means that we have found that there is a sufficient showing for us to get to that stage of this proceeding before we close the evidence. So I hope that's clear. So with that, Ms. Ammons, I think you answered this already, but I'll ask you again. Do you have any 89-151 evidence that you want to present to the committee?
No, I do not.
Okay. Mr. Duckett, do you have any 89-151 evidence that you want to present?
No.
Okay.
If I may, put on the record that Mr. Bell does not have any prior discipline. So that goes to 89-151.
Thank you for that. Okay, well, if no one has anything else, then the record is closed. And we will have post-hearing briefs, following which the committee will issue a report and recommendation to the disciplinary board, and then it goes from there.
May I request?
You may.
Okay, so the case was not dismissed. So Aaron Bell did not prove his case. And the disciplinary board did give enough information that probably there was a infraction. Probably they're gonna have to go through all of that paperwork, and they make a recommendation, and they give it to the Office of Disciplinary Counsel, and then it goes up to the Pennsylvania Supreme Court, and then we find out. Now the choices are down to 3. He's either going to get censored or sanctions, publicly or privately. He's going to get disbarred, or I think that's it. That's it. He's going to get censored or sanctions or disbarred. Something's going to happen. Well, no, that's not true. That's not true. The Supreme Court could say, no, this is all bull. Dismissed. They could do that. That's still possible. It's still on the table. But it did go further. All right, guys. I have a little bit of house cleaning I need to tell you. I'm taking 4 days off. Let me get my calendar up. I'm taking Friday the 19th, the 20th, the 21st, and the 22nd. So I'm going to stream Thursday morning at 4:30 like I always do, the 18th. And then I will not stream again until, Tuesday the 23rd at 4:30 a.m. I'm moving, and I'm taking 4 days off. I'm going to sleep. I'm going to play in my great big backyard. I'm going to, I don't know, do whatever I want to do. But I took off work too. Taking 4 days off of everything, and so I can move and unpack and clean, and I know this is the longest I've ever taken off since I started over 3 years ago. I think 2 days has been my max, and now I'm taking 4 days off. So thank you for coming out today. I really, really appreciate it. I really do. I shall see you all again. I don't even know what today. Today's Friday. I have off today. Tomorrow morning. Everybody behave, okay? Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy